Welcome everybody. Thanks for coming. Thanks for joining us on not the easiest night for being in looking at a screen as the temperature seems to keep rising. My name is Michael Clegg and I'm the Secretary of Cambridge for Europe, and my colleague Paul Brown, our chair, is assisting tonight as well. This is our second and final talk for the summer of 2022. We're hoping to have some additional talks in the autumn, maybe even in person if we can get rooms organised and some of those tricky things. We are remaining active over the summer. We're trying to arrange a social event. We'll make sure that we email our members about that, and we'll put up information on our Facebook page. And we're also continuing to work with our friends in Cambridge, in the Cambridge the Cambridge University Ukrainian Society and Cambridge for Ukraine over this summer as well. So for this evening, I'd very much like to welcome Professor Catherine Barnard. Catherine is Professor of EU Law and Employment Law at the University of Cambridge and also a Fellow of Trinity College. She's also the Deputy Director of UK in a Changing Europe. As I'm sure you'll be aware, she's one of the UK's most respected experts on EU law and the relations between the UK and the EU. And in recent years, she's become an in-demand commentator on Brexit within the UK media, getting beyond sloganising to analyse practical real-world impacts and policy choices. So Catherine will start with around half an hour's presentation, and then we'll move to questions. If you want to ask a question, as ever in the Zoom format, if you could put it in the chat, please, and could you clearly mark it as a question? So if you can just put the word question at the beginning of your question, we can make sure we can spot questions from amongst the detritus of the chat function, if I can put it that way. And Paul and I will, just to keep things crisp, Paul and I will read out the questions, I think. Okay, so thanks very much again. Thanks to Catherine. And Catherine, if that's okay, I'll hand over to you.
Well, thank you very much indeed. It's a great pleasure to be here, and thank you to all of you who've given up part of your evening when no doubt the barbecue was calling, or a lie in the, well, not quite sunshine, but it's still a great privilege to be here. So I've been asked to talk about Brexit and beyond. And what I thought I'd do this evening is to just give you a very brief reminder of what's happened over the last 6-7 years before looking at a little bit about the Trade and Cooperation Agreement, which is the main basis on which we are now trading with the EU, before talking about the Northern Ireland Protocol Bill, which I think is the biggest stumbling block for any future relationship that we might have with the EU, and then finally a bit about the so-called Brexit Freedoms Bill. So I'm going to try and rattle through all of this, and here goes. So first question, briefly, just a reminder how we got here, because it really has been quite a ride, and you may well have forgotten some of the stages because it has been going on for so long. But the main milestones were, of course, that after the vote to leave on the 24th of June 2016, when we heard that there was indeed a majority to leave, eventually negotiations started on the withdrawal agreement. The withdrawal agreement was in fact concluded in October 2019, and the withdrawal agreement is a divorce text, and it's that text which includes the Northern Ireland Protocol. Now, the withdrawal agreement was implemented into UK law by the EU Withdrawal Agreement Act 2020, which largely amended the EUA 2018. Now, the EUA I'm going to come back to later on, but just to remind you, the EUA was a decision by the UK to essentially dump the whole corpus of EU law into UK law as retained EU law. And that's the thing that Jacob Rees-Mogg wants to be turned off. So we negotiated the divorce text, the withdrawal agreement, implemented that into UK law, and formally left the EU on the 31st of January 2020. But in fact, we went into some sort of holding pattern, and that holding pattern was called the transition phase, or what the government insists on calling the implementation period. And that lasted until the end of December 2020. And it was in that period from March to December 2020 that the Trade and Cooperation Agreement was negotiated, and the Trade and Cooperation Agreement is the deal under which the UK and EU now currently trade with one another. And I should say at the outset, it is a very thin deal. Thin not in terms of paper, it runs to about 2,000 pages, but thin in terms of content. And I'm going to tell you a little bit about that in a moment. And that deal rushed through Parliament in a day with zero scrutiny. It meant that we left the EU, absolutely all of our former EU membership ties were severed on the 31st of December 2020, and we are now trading under the Trade and Cooperation Agreement. So I'm going to say just a little bit about the Trade and Cooperation Agreement first, so you can just get a sense of just how different it is from what we had under EU law. Now, the Trade and Cooperation Agreement, the TCA, looks a bit like this. And if you're thinking about it, think about it a bit like a sandwich, with the two horizontal boxes as the bread, and then the meat is in the middle. Now, across the top, you have the common institutional provisions. And there are a couple I want to draw to your attention. The first one is this is very much an international agreement. It's got nothing to do with EU law. The UK was determined it would have nothing to do with EU law, and therefore it meant that there would be no role for the European Court of Justice. And so you can see it's to be interpreted in accordance with the Vienna Convention of the Law of the Treaties, which is the document that guides our understanding of international trade agreements. And then at the bottom, there are common dispute settlement provisions, which I will return to in a moment. Then you've got the meat in the middle, and the core part of the meat, and I will just put a pointer on so you can see it. The core part of the meat is here, and that is the free trade agreement, which essentially is what's called a 0-0 agreement. Zero tariffs and zero quotas, but that is it. It is very, very slim indeed. Somewhat more surprising, and positively so, is that there was a greater accommodation, agreement for cooperation in respect of law enforcement matters. There was hope that the UK would join some of the programs, including Horizon. That has not happened, in part because of the ongoing disagreement about the Northern Ireland Protocol. Now, this is the basic structure. Other point to note, see at the bottom, its implementation is to be reviewed every 5 years, which takes us to the start of 2026. Of course, we're due for a general election in 2024 at the latest, and there is a reasonable chance, depending on the state of the Tory party by then, that it could be in the Conservative manifesto that we leave the Trade and Cooperation Agreement as well. And that would be the equivalent of leaving with a no deal. Some of the hardest Brexiteers are very much in favour of this. They just see the TCA as a stopgap provision till manufacturers recognise that it's fine to be on the outside of the EU. For the sake of completeness, just to say that in fact, although we talk about the Trade and Cooperation Agreement, there are a couple of other agreements as well, very specific agreements, which covered things like security and nuclear energy. But the bottom line is the bulk of the text is what I describe here. Now, I've emphasized to you, this is very, very different to what you have on what you had under EU law. And to really illustrate that point, I'm going to focus on the key bit of the agreement, which is about goods. And what I want to just show you is that what you actually have in this agreement is not free movement minus. What you have is GATT plus. Now, for those who aren't familiar with the terminology, GATT is the original agreement when under what's now called the WTO. And GATT is better than nothing. It allows states to trade with each other, but they trade with each other essentially on the basis of tariffs. And there are a number of agreements under the GATT to ensure that goods can move between contracting parties. Now, I don't want to get too bogged down in the detail, but what I just want to show you is down here, these are the relevant GATT agreements. There's a GATT agreement on rules of origin. There's a GATT agreement on sanitary and phytosanitary matters. So that's health of products. There's agreement on technical barriers to trade. And there's an agreement on trade facilitation. What do you get in the TCA on goods? Almost a mirror image. Look, chapter on rules of origin, chapter on SVS, chapter on TBT. So even just looking structurally, you can see that what we have in the TCA, the Trade and Cooperation Agreement, is already very thin gruel. It is very, very thin indeed. It is basically GATT, and as I say at the top, a little bit plus. It's a little bit better. And it's a little bit better than GATT because we're under GATT, the goods which are traded can be subject to tariffs as long as those tariffs are the same irrespective of where the goods come from. Under the TCA, it's a bit better than that. It's better than that because there are 0 tariffs. There are 0 tariffs on goods moving from the EU to the UK and vice versa. And if you, for those of you who'd like to look at the detail is set out here. But, and it comes with a huge but. Yes, it's 0 tariffs, but you've got to be able to prove that the goods originate in the UK or in the EU. And that requires a vast amount of paperwork to prove that the goods in fact do originate in the UK and in the EU. Now, with some products, you know, like water, it's pretty obvious where the product originates from. But the more complex the product, it's much harder to prove where the goods originate from. And what we've seen since the TCA has come into force is a couple of rather remarkable things. One, for small businesses, proving rules of origin, proving where your more complicated good comes from, is so difficult and so demanding for them that they actually don't bother and they just pay the tariff. The second thing that we've seen is that although exports have broadly held up UK, EU, in fact, if you dig a bit deeper, the composition of those exports has changed remarkably. What that means is it's big companies with big trade departments who have carried on trading with the EU because they've been able to have the expertise and staff to do the work on making sure that their goods, they produce the relevant paperwork to show rules of origin. Small companies have, a lot of small companies have just stopped trading with the EU because it is just too difficult and too complicated. And that's very bad news. It's bad news for those individual companies. It also means that the bigger companies get bigger and stronger with the risk of monopolistic behavior, and smaller companies aren't there nipping at their ankles. And even though I've been talking about a 0-0 deal, in fact, what we've really got is, yes, it's 0 quotas and 0 tariffs, but still goods are subject to import VAT, which is why if any of you've sent your grandchild who lives in Italy a teddy bear, that will hear wails from their parents that they've had to pay £50 in duties. That's the import VAT that they're having to pay on goods moving from the UK to the EU. The other thing to note, this is too small for you to read in detail. I don't want you to look at lots and lots of detail, but this is how to trade organic products. Pre-Brexit, it was just this. That was the paperwork. That was pre-Brexit. Post-Brexit, this is all of the stages for importing the same product since we have left the European Union. Now, what you can see straight away, and the point I'm trying to make here, is that, of course, the rules have changed and it has become so much harder. It therefore comes as no surprise at all that smaller companies have just stopped doing battle with all of that level of bureaucracy. Next thing I want to say is a little bit about the governance mechanism. So that's how the sort of various bodies that oversee the operation of the Trade and Cooperation Agreement. And there's a couple of things I want to draw to your attention. So the way it works is like this. At the top, you have the Partnership Council, which is comprised of politicians. And then underneath it, you have specialised committees. The remarkable thing is the Partnership Council is meant to meet annually. The last time it met was in June 2021, and there have been no plans whatsoever for it to meet again. It's not even scheduled into anyone's diary. And that's because it really does show that at the moment, the EU and the UK are in such a bad place in respect to their relationship with each other that neither side thinks they've got anything to talk about. And yet there's a huge amount to talk about, some of which will come up in these various specialized technical committees. Not least, look at the problems that I was telling you about just the level of paperwork that importers, exporters have to manage in order to trade with the EU as compared to the situation before. Now, the other thing that has happened, slightly more positive, is the Parliamentary Partnership Assembly, the UK-EU Parliamentary Partnership Assembly. It's taken a while to get set up, but it has now been set up. And it's been set up, and indeed it has now met. The start of the meeting was somewhat marred by political grandstanding on both sides, but after that I'm told that the conversation between the EU and the UK parliamentarians was pretty positive. Do note, however, that the representatives from the UK are all drawn from Westminster. There is no role, no formal role at least, for anyone from any of the devolved administrations. So I've said to you something about the overall governance structure. The other point to note from this is that decisions are taken by consensus rather than qualified majority voting, as you saw a lot when we were members of the EU, which again reflects the fact that it is an international agreement. The other thing that is really dramatic in the change from what we had before to what we have now is about dispute resolution. Now, this might sound and feel somewhat techie, but in fact, it's going to become very important in the autumn, depending on how the new leader of the Conservative Party takes matters forward. But what I want to draw your attention to is that the procedure, when things are going wrong, is basically a procedure which you find under the WTO, and it's also a procedure you find in other free trade agreements. And in a there are three stages to it. There is a political stage, then there is a more judicial stage, and then there is a compliance stage. The political stage involves consultations in the Partnership Council. And remember the Partnership Council, that was the top dog body I talked about over here. And if those consultations don't produce a result, then the matter goes to arbitration, and the arbitrators can find against a particular country. If the arbitrators were to find against the UK, then the UK is obliged to comply. And if it doesn't comply, then so-called temporary remedies are applied. What are those temporary remedies? Well, it's basically tariffs. And what the EU is extremely good at is identifying weakness in its rivals or in its opponents. And so it's likely that those tariffs will be imposed on things like Scottish salmon, Scotch whiskey, cashmere, and anything that's made in a red wall seat, because it knows that those sorts of tariffs are particularly painful for internal domestic reasons. So I've just given you a sort of whistle-stop tour, and the message I'm trying to get across is for anyone who thinks that the TCA is in any way similar to what we had as member states of the EU. The answer is no, this is not correct. And I've given you some examples of just how and why it is so different. What I want to focus on now is the Northern Ireland Protocol. And the reason why I want to spend the next 10 minutes or so talking about the Northern Ireland Protocol is it's become such a crucial issue for both sides. And it's become almost neuralgic for both sides, and it is very successfully blocking any future cooperation at the moment between the UK and the EU, hence why the Partnership Council hasn't met. Just to remind you of the problem, and the problem is what's referred to as the Brexit trilemma. And the Brexit trilemma over Northern Ireland essentially says you can have two of any of those three things, but you cannot ever hit the sweet spot of having three of any of those three things. You can only have two. So I'll explain. If, as the UK wanted, certainly under Boris Johnson, to leave the EU's single market and the customs union, there would have to be a border somewhere, a border to demarcate the edge of the EU. Now, there are two options for where that border can be. That border can be north-south, i.e. between the north of Ireland and the Republic. But the trouble is that is against the spirit of the Good Friday Agreement. So the other place for a border is that there's got to be a border east-west between GB and Northern Ireland. Now, in fact, that is the consequence of what Boris Johnson signed up to. Now, he never recognized the Brexit trilemma because he said it doesn't exist and we can have all three things. We absolutely cannot have all three things, as Theresa May discovered. Theresa May realized this, and for Theresa May, she said having a border down the Irish Sea was totally unacceptable because you don't want to partition off part of your country. So in fact, she sacrificed this one. She said GB would stay in the customs union with the EU. And therefore, that was her compromise, and that would have avoided this problem of no border between north and south and east and west. Boris Johnson said, actually, there's no such thing as a Brexit trilemma. And the way he, I'm afraid, misled on this point was to say, we're leaving the single market and the customs union. And as I've shown you with my brief description of what's going on in respect of goods, that's absolutely right. There is no hard border between the north and south. And he said, actually, there's also going to be no border between the east and west. This is fundamentally untrue. And indeed, the impact assessment which accompanied the withdrawal agreement makes it very clear that there is going to be a border between the east and west. Now, as you also know, this has become totally unacceptable, first to the Democratic Unionist Party and now to the Conservatives. And that's why they have put forward the Northern Ireland Protocol Bill. Just before I get to the Northern Ireland Protocol Bill, this is a summary of what's in the Northern Ireland Protocol at the moment. What you can see here, some provisions on safeguarding rights, especially the equality rights, and some institutional arrangements. The crux of the Northern Ireland Protocol is here, Articles 5 to 10, which are the effect of those provisions is to put a border down the Irish Sea, the so-called east-west border. And then the other provision, which is deeply loathed now, we discover, by the UK government, is the provisions on governance and specifically giving a role to the European Court of Justice. Now, of course, remember that this is an agreement that the current government signed up to in October 2019, so less than 3 years ago. And it's a government that signed up to this agreement in full knowledge of the consequences. There are a large number of contemporaneous reports that make it clear that the government knew what it was signing up to. But they say now that this is unacceptable, particularly the role of the European Court of Justice. And so therefore they want changes. And they say that they have been trying to negotiate changes, but the EU will not cooperate. I think it's very striking that, I think it was last week, the outgoing Irish ambassador to the EU published a letter in the Financial Times to make it very clear that it's not the problem is not the protocol in and of itself that causes issues in respect to the Good Friday Agreement, but Brexit. But of course, this is the subject that dares not speak its name. So what has the UK done? Well, as you know, it put forward the Northern Ireland Protocol Bill, which in essence does the following things. It establishes a green channel for goods to make it easier for goods to go from GB to Northern Ireland, to reduce the level of paperwork and to reduce the level of checks on goods going from GB to Northern Ireland. It's also saying it's going to establish a new dual regulatory model, and that means that manufacturers in Northern Ireland and indeed the UK can decide whether to apply EU rules or to apply UK rules. And providing they only sell their goods in Northern Ireland, it's fine for them to comply with UK rules. And then they also want to reverse the provisions on subsidies. They want UK subsidy rules to apply. And they also want to remove the role of the European Court of Justice. Now, Boris Johnson described these as minor tweaks. I'm afraid this is also fundamentally incorrect. These are not minor tweaks. Going back to my diagram, all of this is going to disappear. Much of this is going to disappear, and much of what's in the red box, the red ring, is going to disappear. This is not minor tweaks. This is a fundamental rewrite of the Northern Ireland Protocol in a way that to try and achieve some of the things that they failed to get in the negotiations back in 2019. Now, the bill is going through Parliament. You will have seen that at second reading, even though a number of Conservative MPs stood up and said that they were not happy with the bill, they nevertheless abstained rather than voted against. And I think as we're speaking, the committee stage of the bill is currently being conducted on the floor of the House. Now, what's the justification that the government has put out there for doing this really fundamental redrafting of the bill? I'll come back to that in a moment. The government says that it's justified in doing this for reasons of necessity. Now, it points to Article 25 of the International Law Commission and the Law Commission's articles on state responsibility. And the International Law Commission and its articles on state responsibility say that the state can indeed renege on its commitments under international law if there is a grave and imminent peril. Now, things are bad, but they are not, I don't think, and most other people who've commented don't think they have reached the stage of grave and imminent peril in Northern Ireland. And even though we're in the height of the marching season in Belfast at the moment, touch wood, it has been fairly peaceful. And furthermore, if you're facing grave and imminent peril, the fact it's going to take a best part of a year to get this bill through Parliament does tend to undermine the argument that there is grave and imminent peril. And so most people think the government's justification for putting forward the Northern Ireland Protocol Bill is extremely thin. And that's certainly the view that the European Commission has taken as well. Now, you might have heard quite a lot about Article 16. And you might be wondering, well, what about all this stuff on Article 16 that we've heard about? What is Article 16? So I will try and explain. Article 16 is what's called a safeguard clause. And under the safeguard, if there is a very specific problem which causes environmental or societal issues, then it is legitimate to suspend part of the operation of the Northern Ireland Protocol. And that's what I've put there. If it's triggered correctly, and there is a process that needs to be done, if it's triggered correctly, then the UK would be acting lawfully if it takes limited safeguard measures. And then the EU can respond, but again, in a very measured way. The problem is, as I've shown you, the Northern Ireland Protocol Bill doesn't make tiny changes. It's not targeted. It's a whole-scale rewriting of the Northern Ireland Protocol. And in fact, it just means that Article 16 cannot be used, because Article 16 is about dealing with a surgical strike, a very specific problem. For example, there is a genuine problem at the moment of veterinary medicines getting into from GB to Northern Ireland. Now, if we had decided to use Article 16 to resolve that problem, that would have been lawful. What Article 16 cannot be used for is this whole-scale rewriting of the Northern Ireland Protocol. And it absolutely cannot. It's intended as for this very targeted use. Now, we were told back in March that Suella Braverman, one of the current contenders for the Conservative leadership, backed a move to trigger Article 16. Now, it's interesting that they have not used Article 16 despite Suella Braverman's support for it. Indeed, in the government's own legal advice, it says we're doing what we're doing, i.e. ripping up the Northern Ireland Protocol on the grounds of necessity, but they are not using Article 16 because Article 16 cannot be used legally to rewrite the entire protocol. So where does this leave us? The government keeps saying we're keen on a negotiated solution. And that is certainly envisaged by the Northern Ireland Protocol. But negotiated solutions do require the two sides to come together. And as I've already indicated to you, the Partnership Council has not met since last summer. And the relevant other committee, the Joint Committee, hasn't met since February. So I think for all the protestations about negotiated solution, there really is very little appetite for it. So it looks like we're heading down this bit of my slide, where the UK is unilaterally rewriting the terms of the Northern Ireland Protocol. So what can happen next? Well, two things. One, enforcement proceedings. I'll explain that in a moment. And secondly, more seriously, the dispute resolution mechanism, and I'll explain that. So the first thing the Commission has done is to start enforcement proceedings against the UK. And the way that works is that the Commission has said that the UK is in breach of its obligations under the Northern Ireland Protocol. Crucially, they are not challenging yet the Northern Ireland Protocol bill. What they are challenging is the UK's unilateral extensions of grace periods. And they've also challenged the fact that the UK has not built border control posts and they've not been supplying enough data to the EU. And so what you see is we're currently in this pre-litigation phase, and the UK has got to respond with a reasoned opinion by the 15th of August. Now, this is interesting because, as I've already said to you, one of the things that the Northern Ireland Protocol Bill does is to turn off the role of the European Court of Justice. So it's quite possible that a hardcore Brexiter leader of the Conservative Party will take the view that we're not going to play ball with the EU over this process because we no longer recognise the role for the European Court of Justice. If, however, we do say that we will offer our views and talk about Article 25, the case will end up before the Court of Justice. And if the Court of Justice finds against us, it will issue a declaration and that the UK has got to put things right, which of course it won't do because it wants to keep its Northern Ireland Protocol bill. And so we can be subject to fines and penalty payments. And then the question is, will the UK actually pay them? So this is what's already been started, and it's already laying the ground for high political drama because the UK might just effectively say, we are not playing ball. So that's the first thing that can be done. The second thing that can be done is that the EU starts the dispute resolution mechanism under the withdrawal agreement. And that's very similar to the dispute resolution mechanism that I showed to you before under the Trade and Cooperation Agreement. There is a political stage, followed by an arbitration stage, followed by the obligation to comply. And it may be that the EU says we're going to start with the political stage, and if that doesn't work, we'll go to arbitration. And if the arbitration panel finds against the UK's got to comply. And if the UK doesn't comply, we're in the world of what's called temporary remedies. And all of those numbers essentially mean that the EU can start imposing tariffs on us. Tariffs on all of those products I mentioned to you before. Now that essentially will lead to a trade war, because the UK will get very cross and will not take this lying down. So in fact, the EU might decide to do something else entirely. And these are a range of options that the EU could take. It could decide, and indeed I'm told the Germans have been seriously discussing this, just to give the UK 12 months and terminate the whole trade and cooperation agreement. Or it could decide under Article 521 to terminate the trade part of the trade and cooperation agreement. So that means tariffs get reimposed. Or the UK can say that the Northern Ireland Protocol Bill is so serious, and it means a serious and substantial breach of the rule of law, and therefore the whole TCA gets suspended, and the list goes on. The bottom line is that we are heading towards a major standoff with the EU, probably in the autumn, and it will be one of the biggest challenges facing the new leader of the Conservative Party. And the striking thing about the new leader of the Conservative Party is that they are all committed, even Tom Tugendhat, who's probably the most centrist of the candidates, to carrying on through with the Northern Ireland Protocol Bill. It's immensely serious for the UK-EU relationship, and it could get so nasty that the whole TCA, the Trade and Cooperation Agreement, which I know I've already described as very thin, but it is better than nothing. The whole relationship is brought crashing down. The final thing I want to say in the last couple of minutes that remain to me is something else that you need to watch out for. And that is the Brexit Freedoms Bill. It won't actually be called that. Now, if you remember, right at the start of my talk, I talked about something called retained EU law. And if you remember, I said back in 2018, the UK decided to dump the whole body of EU law into UK law. And it did it by the EU Withdrawal Act 2018. And that law, that whole corpus of EU law, was given the rather unattractive name of EU retained law or retained EU law. And the argument, which I think was a good one, was that the reason why the UK government did this was for legal certainty, to make sure there was a functioning statute book on Brexit Day. So it took essentially a snapshot of the whole body of EU law and dumped it into UK law. The trouble is, the view has been developed that all of that law, which came from the EU, is undemocratic. And it's undemocratic because it comes from the EU and has not been approved by the Westminster Parliament. Now, the very fact that the UK had a significant say and a disproportionate influence in the Council of Ministers, which adopted a lot of this legislation, gets lost in the telling. The perception now is all of this law is undemocratic, and Jacob Rees-Mogg, the Brexit Opportunities Minister, wants it to be turned off. So two things have happened. The first is that a so-called Brexit dashboard has been set up, which you can Google if you like. And so you can see how much retained EU law is still on the statute book. And if there are particular bugbears that you don't like, the most famous one is the working time regulations. You can see if it's still on the statute book. You can see which are the relevant government departments who are responsible, and you can see whether it has been amended or not. Personally, I find this dashboard incredibly difficult to use, and although it looks pretty, it's very difficult, I find, to actually navigate your way around it. And I know what I'm looking for. So it's not clear to me how many members of the public would actually go onto this dashboard. So that's the first thing that they've done, is to map all of the retained EU law. The second thing they've done, and this is Jacob Rees-Mogg's baby, is to say that they want to try and turn off all of retained EU law. Now, I understand that there is still a big debate in Cabinet, as this Guardian story indicates, and it's still ongoing, about whether there should be a sunset clause of, wait for it, the deadline being the 23rd of June 2026, i.e. 10 years after the Brexit vote, to turn off every single piece of EU law, irrespective of whether it's good law or not, irrespective of whether we think that we are actually quite happy with the law in that area. Now, this is currently being debated. It will be, again, one of the big issues facing the new leader of the Conservative Party, about where they want to position themselves, whether they absolutely want to turn off all of this legislation, or whether they want to have a slower and more considered process for turning it all off. Bottom line is that Brexit is far from done. Brexit is the gift that keeps on giving, and Brexit has the capacity to put us into a deep and very highly toxic relationship with the EU for so long as the Northern Ireland Protocol Bill is on the table. Thank you very much indeed.
Thank you very much, Catherine. That was tremendously wide-ranging and very clear at the same time. So that was tremendous. We've got a few questions in the chat. Do keep them coming. That said, I'm going to take Chair's prerogative and ask the first question, if I may. And I'm going to ask a relatively low-octane question, perhaps, before we get to the perhaps some of the issues around the Northern Ireland Protocol, which might be a bit more heated. I just wanted to ask about the governance arrangements and the Partnership Council. So my question is, if there was goodwill on the part of Westminster politicians, on the part of UK politicians, could some of the issues, particularly some of those issues around the bureaucracy affecting trade, so thinking about your diagram relating to, I'm not sure there was export or import actually of organic goods, could some of those issues be dealt with within the existing TCA, or is that kind of amendment is that impossible to do within the existing governance arrangements?
Yeah, thank you for that. Absolutely, it could be dealt with through the existing governance arrangements. Now, a more significant step would be for the UK to sign up to some sort of SPS or veterinary agreement with the EU, which also would help a lot, not entirely, but it would help a great deal. And this is where it gets difficult, because at the moment we've got the purists, Brexiteers, who seem to be in the ascendancy, who see anything which is smacks of an agreement with the EU to be some sort of compromise of their sovereignty. And the pragmatists who say, well, look, we have absolutely left the EU, but we are making life for a business very difficult, and the evidence is showing now that perhaps there's about the fact that food prices are rising so much, about 6% of that is attributable to Brexit. If you look at the medium to long-term effects of Brexit, probably about 4% of GDP. You could see that actually businesses do need a helping hand. And that does touch upon some of the questions that are in the chat about why haven't businesses spoken out? Well, the businesses essentially, this is a vengeful government. And in the early days post-Brexit, anyone who went in to see a minister who was not arguing that Brexit was great and how could we make it even better, was quickly dispatched with a flea in their ear. And it still goes on. If you look, the CBI, for example, has been totally marginalized throughout the Brexit process. And so I think we have got, particularly if Liz Truss or Suella Braverman becomes the next leader of the Conservative Party, you'll see that both are committed to pulling out of the European Convention on Human Rights. This has got nothing to do with the EU, but it's still part of the same rhetoric that parliamentary sovereignty is being curtailed.
Thanks for that. Perhaps I could ask then Estelle Wolfer's question, which I think is in some ways connected. So Estelle saying that she's surprised that the devolved administrations have not been more vocal about not being represented in the Partnership Council, and asking sort of why that might be, particularly in relation to Scotland, or is it in fact the case that they are making representations, we're just not hearing about it?
Yeah, it's both. Thanks, Estelle. So the treaty expressly says that the Partnership Council, a Partnership Council and the Parliamentary Partnership Assembly are both Westminster, because there is a competence issue, and the competence issue is that treaty making powers rest with Westminster and not with the devolves. They were very keen to participate in the Parliamentary Partnership Assembly, and in fact they were given observer status, and so there has been some more constructive dialogue with the devolves over that. But it is surprising that the devolves have not been pushing harder over the Partnership Council. And I mean, I think there's a lot of wounded feelings particularly in Scotland and Wales, because they have been so sidelined throughout, and every time a piece of legislation is proposed which requires a legislative consent motion, they have refused consent and the government's gone ahead regardless. And you see that with the 2018 Act, the 2020 Act, the UK Internal Market Bill, and it looks like they won't give their consent either to the Northern Ireland Protocol Bill.
Thanks for that. Paul, do you want to come in? I think you'd put a couple of questions in the chat. So do you want to ask those yourself?
Yeah, I mean, I guess what it comes down to is the old question of good faith and negotiating in good faith. And I was wondering if Catherine has any view on to what extent that is the key thing for the EU at this point. I mean, what she was when she was discussing the Northern Ireland Protocol, but it really struck me as if it was almost could be used by some of the hard Brexiteers who were trying to torpedo the TCA to actually do that without actually the UK withdrawing, essentially forcing the EU to kick us out of it, and also with ECHR and withdrawing from that. I mean, that's also written into the TCA and into the the Good Friday Agreement and various other treaties. Is that question about whether, you know, is good faith, is there expectation of good faith that they really just don't have any at the moment?
I think there is a total breakdown of trust on both sides. The EU, for reasons which are very obvious, which is they keep saying, you agreed to this, you knew what you were agreeing to, and now you've reneged on it. And so lots of allegations of bad faith. On the UK side, they would say, well, we didn't realise quite how it would work on the ground, and that the EU has been disproportionate in its application of the existing rules. Now, that may or may not be true, but that doesn't quite add together, because the Northern Ireland Protocol Bill goes way beyond dealing with disproportionate application. Not least, it's removing the role of the Court of Justice, which up until now has had no involvement in the Northern Ireland Protocol. I think the one thing is worth bearing in mind, and I've had this from various sources, that there was an absolute paranoia amongst Brexiteers in October, November, December 2019, that they were going to lose their Brexit. And they saw all of these parliamentary manoeuvres by Hilary Benn, Alistair Burt, the Benn-Burt Act, which Lord Frost repeatedly describes as a surrender act, which he saw as tying his hands to force him to make a deal on whatever terms. And I think Lord Frost's view, he talked to UK and a Changing Europe a couple of weeks ago, was that they would do anything to just make sure that they got a Brexit deal, and so that we could leave, because I think his belief was that the democratic consequences of not leaving would have been far worse. And so I suspect it's slightly more nuanced than the way the EU present it. But the bottom line is we are now in a very difficult situation. And I think it's also striking, not just this government, but the Theresa May government too, has favoured the DUP over Sinn Féin and others. And traditionally, the Westminster government has tried to be even-handed between the two sides. It is now seen as so pro-DUP that it's marginalised Sinn Féin. Sinn Féin, you'll recall and you'll remember, got the largest number of seats in the May elections. And the question then is what happened? What does Sinn Féin do next?
Yeah, no, I absolutely agree. I mean, one of the things you mentioned earlier that the problem is Brexit was that article you referred to, and that's something you don't really hear about here, but certainly among Northern Ireland parties, including also the Alliance Party, which is the cross-community party, have very much been making that case. But it's just you just don't really hear about it over this side of the pond.
Yeah, absolutely.
Okay, we've got a couple of hands up. Those people might have missed my introduction when I did ask if questions could be put in the chat, but I think we will unmute you. Could you unmute John White, Paul? Is that possible? But could you please keep your question succinct and to the point, please? Just doing a bit of clicking.
I do apologise. I must have accidentally raised my hand. I don't have a question.
Oh, okay. Not to worry. Well, in that case, sorry, Paul. Could you try Martin Khan? Actually, I think Martin's might have just gone down. Perhaps Martin's taking his down.
I think he just disappeared as I was about to click on him.
It's the I think Martin might have raised something in the chat. It's the heat. I find my laptop, does all sorts of funny things because it's a heat-sensitive touch panel, I think, and so who knows what's happening.
I don't know if you want to look for questions. There's a question from Peter Miles. Have there been any similar issues to the Northern Ireland Protocol for Gibraltar? As he hasn't heard anything for a while from there since on Brexit. And actually, confess, neither have I for a couple of years or so.
You're right. Thank you for that. You're right. It's gone very quiet on Gibraltar. The UK ambassador to Spain, who used to work for DEXU, the Department for Exiting the EU, who actually has a Spanish wife, has been carefully negotiating with Gibraltar. I understood that there was going to be some sort of agreement about 6 months ago, but nothing has happened. So I think progress is clearly not significant at the moment.
Okay, thanks.
Thank you for that. So I was wondering, actually, I'm not sure. Oh, Martin, you've just come in. I arrived late and I didn't want to ask a question. Fine. Well, maybe. I know Catherine was eager, given the heat, to not prolong things too much. So, shall we make Martin's the last question, Catherine? Is that?
Yeah, that's absolutely fine.
Yeah. Michael, we've got one question from Don Oxty about the Horizon programme. Maybe you can have that quickly after Martin's, if that's okay.
Okay, well, if that's okay, we'll just do those last two. So, Martin, are you? Sorry, Paul. Could you unmute Martin?
Okay. In March this year, the issue about comprehensive sickness insurance, which affected EU citizens who are, for instance, in my situation, my wife is Polish and has not applied for British citizenship because she was unclear about the situation, was settled by the European Court of Justice because apparently they still have jurisdiction on this matter for 2 years after the actual withdrawal. This has been a long-standing issue in which the British government has taken a rigid view, and the EU eventually won. How is this? How are there? There's been no publicity. Presumably, they're not pleased about the results. So nobody, eventually, unless you really went looking, you would never find out about the change in the situation. How are issues which are actually going to the European Court of Justice while it still has power? How are they being treated by the government? Are they respecting them? Are they going to reject them? Do we expect to have continuing battles on these issues where a decision is made?
Thank you very much for that. So you're right that over so-called citizens' rights, the Court of Justice still has jurisdiction until I think the end of 2028. And forgive me. And in fact, there has been a case, but the case was about a British woman in France who wanted to retain her EU citizenship rights. She'd worked for the Foreign Office, and so she felt because she had sworn a relationship of allegiance to the Crown, therefore she could not take French citizenship. The Court of Justice took a pretty dim view of that and said, well, the choice is hers, and she certainly could be a French citizen. But the bottom line is Brexit means Brexit, and that means that anyone who holds British citizenship does not get EU citizenship rights anymore, because EU citizenship rights or rights of free movement are conditional on you holding the nationality of a member state. And so from that point of view, it's actually a rather unsurprising legal decision, legally, politically very disappointing for a lot of people. In respect of someone like your wife, who I imagine is living with you here in the UK, she should have got, and I imagine has got, settled status. And to be fair to the government, the settled status scheme has worked pretty well, except for some of the most vulnerable people. And even in respect to the most vulnerable people, the government is trying to sort things out, albeit slowly. And I caution against people rushing to get British citizenship as opposed to settled status, for the simple reason that with settled status, the rights are more generous than you get as a British citizen for family reunification.
Interesting.
Thank you, Catherine. Paul, do you want to ask the Horizon question?
Yeah, so just let me dig it out again. Where are we here? Question, any hope for Horizon 2020, or actually Horizon Europe now, I suppose, or any future cooperation on transnational networks for research at the moment?
No, none at all. I think it's not just no hope, I think it's absolutely finished. And I think the UK government is looking at setting up its own programme. There's a lot of work being done by the Treasury on it. But if you remember, I said that the EU had a number of instruments at its disposal to retaliate against the UK for its approach under the Northern Ireland Protocol Bill. Well, one of the softer ones, but is very damaging for those who are affected, is that they won't participate. We won't participate in Horizon. We'll be blocked from participating in Horizon. Now, down the line, if you had a government which was more willing to engage, it would be possible to envisage something. But until we have a change of government, I think the answer is do not hold your hopes out for Horizon. Yes, George Freeman, the science minister, was doing his best, but he was pretty much a lone voice in a very difficult political environment.
Okay, thanks for that, Catherine. That's a rather disheartening note to end on, but there we go. Perhaps we should face the realities rather than anything else. So can I say thank you again for the talk and for answering the questions. That was tremendously useful. So thank you very much from Cambridge for Europe. I mentioned about some of the events we had planned for the future. So we will be looking to have some further talks in the autumn. We are looking to develop or to hold a social event in the summer. We'll be providing information about that. I see there was a little bit of talk in the chat around the proposed march on Saturday the 10th of September, and I think Paul has shared a link with some more information. And Cambridge for Europe is planning to organise some transport in relation to that. So if you're interested in that, knowing any more about that, then do use our social media channels to get in contact. But otherwise, a final thank you to Catherine. Final thank you to everybody for attending and for those who asked questions. Have a good and I hope reasonably cool evening. Thank you very much.